Alrighty, good afternoon, and thank you for joining us for today's Condo Talk at the CCI Golden Horseshoe chapter. My name is Maria Durdan. I'm a partner at Simpson Weigel Law and the chair of the Condo Practice Group. I'm also currently the president of the CCI Golden Horseshoe, as well as the co-chair of the Education Committee. Condo Talk was created to provide free, short, informative, and practical solution-based webinars to condo owners, directors, managers, and anyone servicing the condominium industry. I would like to start off by saying thank you to our sponsors of today's Condo Talk. We have Elia Associates, condominium lawyers, Robson Carpenter, LLP, Precision Property Management, and DC Restoration Disaster Care. Thank you so much for sponsoring today's Condo Talk. We have two amazing speakers with us today offering legal and management perspectives on condos and COVID. Patricia Elia is a condo lawyer at Elia Associates, a firm that provides a full range of legal services to condos throughout Ontario. Patricia is heavily involved in CCI, which currently includes being the president of the CCI Huronia chapter, the co-chair of CCI National Council, and vice chair of CCI Government Relations. We also have Michelle Joy, and she is the general license manager and registered condo manager and a director of condo management at Wilson Blanchard. Michelle is also a member of the finance and conference committees of the Golden Horseshoe chapter. Welcome, Patricia and Michelle.
Thank you.
During today's Condo Talk, COVID and Reopening Blues, we will review what we have learned over the past year. It has been a year. It's crazy to think that way, right? We would like to share our experiences with you and discuss some of the obstacles and issues that condos have dealt with and encountered and provide practical tips. Alrighty, let's get started. 4 days ago, Ontario issued an additional public health measure in response to the increased number of COVID-19 cases and associated hospitalizations. The newest restrictions are in addition to those that were imposed on April 3rd and April 8th. So as of right now, as they relate to condominiums, we are not allowed to have any organized indoor or outdoor public events or social gatherings. They are prohibited. So no in-person AGMs, if there is ever any doubt. It is quite clear. Only members of the same family are allowed to gather together, and individuals living alone may meet up with another individual or caregivers as well. All indoor and outdoor amenities are to be closed. This includes your pools, your indoor gyms, your outdoor gyms, your tennis courts, your terraces, your barbecue areas. But you are allowed to keep your parks open as well as your playgrounds if you have those at your condominium. Anyone working in a condo must be screened before entering, and there must be notices posted at the front entrances for self-screening. Masks must be worn indoors with some exceptions, which we will be discussing. And construction, non-essential commercial construction is prohibited, and residential construction activities and projects are permitted. Whether they should be permitted to continue is a whole other story, which we will also review today. So without further ado, I will now hand it off to Michelle to talk a little bit about back to basics. Where are we today after a year into this? Michelle?
Thanks, Maria. So to start us off, I kind of wanted to look at the last year. As Maria said, I truly cannot believe, I think it's been about 14 months, about a year since the pandemic began. And I think we've all had an opportunity to learn a lot. So I wanted to throw out a few kind of refresher tips that a lot of you may know, but from a management perspective, I do feel that over the past year in dealing with all that we have had to deal with, some of these key items I think have kind of fallen by the wayside. So I kind of want to give a few tips, which may seem really basic, but just as a refresher. So one of the big things, and this, I think we talk about this all the time, but one of the biggest things in condos is communication. So I'm hoping that most of your buildings or your properties haven't only sent out, one COVID-19 notice update back in the spring of 2020. Continuously communicating with your community is definitely the key to getting us all through this together. So ensure that board and management is regularly providing updates. We all know how quickly this is all changing. So somewhere like, a central notice board or a website where you can post updates for your community and how the provincial changes affect your community, that's something to really stay on top of. Another thing that I feel has kind of decreased in some communities is, I know at the beginning, and I'm sure a lot of you can relate, there was a lot of heightened panic almost about, could someone in my community have COVID? I noticed so-and-so came back from vacation and, I saw them in the corridors, and there was a lot of COVID policing and COVID reporting. And I feel like the awareness on that has decreased a little bit. And maybe it's, I don't want to use the word comfort, because I don't think any of us are really comfortable in living with this, but just the time that it has passed and we've all kind of adjusted to it, that we may have forgotten the importance of asking our residents to report if they have tested positive in the community. And just a reminder that information is still strictly confidential. So if a manager gets an email from a resident that they have tested positive, the name, the unit, the floor, none of that should be publicly communicated. It should be left confidential. At the same time, the board does have an obligation to notify the community that there is a positive case within it. So what I would recommend is always consulting with your legal counsel to ensure that you're communicating that correctly, you're not breaching any privacy, and that you're protecting the individuals within your community. So that's when I feel that's kind of fallen by the wayside a little bit, that I think boards and management should ensure that they're reminding their residents of. As Maria noted, we are currently in a stay-at-home order, an emergency order. So I just wanted to touch on that. I know in some of our poll questions, there's a lot of questions about reopening amenities, but right now, unfortunately, that can't be our main focus because they are to remain closed. So again, I think this comes back to communication. I know as a manager working with various communities, you're going to get different opinions, right? There's some condo communities that are very cautious and say, lock it down. I don't even care if the government says we can reopen the gym. We're not comfortable. We're keeping everything closed until we feel it is safe to do so. And then there's the other communities that are like, our owners pay for these amenities. We should open the pool. We should open the gym. So I think communicating as a board, communicating why you're making those decisions is really important to your owners. So again, it comes back to communication, but continuously updating them. So I think one of the questions when we during our planning session was, what are we doing differently? And when I was talking to Patricia and Maria, I said, I don't know if we're doing anything drastically differently at this point. What I think has changed over the last year is, March, April, May of 2020, it was almost, we were living in a panic. We didn't know much about the virus. We couldn't get cleaning supplies or hand sanitizer or any PPE for, our on-site staff. There was panic buying, trying to get that. We were learning as we go. And now that a year has transpired, a lot of the same policies are in place. There has been some changes, and we've learned a little bit along the way, which we're going to dive into a little bit more in this presentation. But I don't know if we're doing a lot differently as opposed to the, I think we're approaching it in a calmer fashion and can make more rational decisions and take the time to make informed decisions because we have more information available to us now. So I think that's really one of the big takeaways is, we're not in that panic stage anymore. We all have had time to kind of sit with this, obviously, over the last year. So what have we learned from history? So what can we take away to move forward? So I think one of the big changes we're looking at now from the last time we've done a presentation on COVID is vaccinations. Vaccinations are rolling out. A lot of our communities are being vaccinated. I think one of the big things we can learn from this is that vaccinations are not 100% protection against the virus. And your entire community may not be vaccinated all at once. So while vaccinations are great and we can look forward to reopening things, I think you still have to keep in mind that we need to be cautious. We can't just open it up to a free-for-all. We still need to have policies and procedures in place to protect our community. Another big takeaway, I think, which was a question posed when we were chatting about this, was are people being nicer to one another, I guess was kind of the short form of it. Are people being nicer to one another? And I think on one hand, what we've learned from dealing with this pandemic over the last year is that kindness and empathy can go a long way. I think all of us process it a lot differently. And when you're dealing with matters within your community, I think you need to take that into consideration. We all have a different comfort level with the virus and the pandemic. And so when you're dealing with enforcement or a matter that arises, you have to kind of think what someone else's frame of mind is. And that doesn't negate the fact that you still need to enforce your policies or procedures that are in place. But I think we've learned that kindness and empathy go a long way in navigating this together. And there, we've also got some direction from the courts, which we're going to touch on a little bit further in this presentation. But that's another thing we can take away from the last year of experience is we have had direction from the courts that the board has the support to implement and enforce the policies with respect to COVID. We've been given guidance that just because the provincial government says that gyms can open or pools can open or whatever your amenity is, does not mean that the condo corporation is required to follow the provincial guidelines. I would say when it comes to reopening, when it comes to shutting down, I would say strongly follow it. But when it comes to reopening, just because your gym can be open doesn't mean it has to be. And the courts have given direction to corporations that their policies can be valid and upheld. So that's kind of a back to basics refresher, just a little quick highlight of the past year from a management experience.
Thanks, Michelle. A good question came in. A spring walkabout that happens at this time of year, which keeps many managers very busy. Would this be allowed at this time? Or how are you guys approaching this from the management perspective?
Yeah, that's actually a great question. Very timely for where we're at. So I would say yes. I would say yes, spring walkabouts could be conducted. I think taking proper precautions. So I think everybody, even though you're outside, should be wearing a mask and try and maintain as much distance as possible. If possible, I would recommend that you try and limit the group size. So I know a lot of the times all 5 board members want to join the manager and the landscaper on the walkabout. In my opinion, not a lawyer, not part of the government, but I think these walkabouts fall under, the walkabouts are, in my opinion, from property management, required in order to address seasonal maintenance. I'm not sure if the government would classify it as a social gathering because I don't think it's for social purposes. I think it's for the purpose of conducting business of the corporation in order to address required maintenance and repair. So I think if you take the right steps, yes, you can proceed with spring walkabouts. And I don't know what the legal perspective might be on that one.
Well, I would agree that you're right. It's something that has to be done to manage even the safety of the property. You're looking for things that could create a risk or create problems in the future. So I think it would still be considered to be necessary. But I think your advice around limiting who's attending is key. And then also putting in place the other layers of questions that we should ask everybody before we get together, even in this smaller group, but still do our best to socially distance, create an agenda, show that it was really tight and organized for a very specific purpose.
Yeah, I agree with both of those comments because when you look at the list of what's permitted under the current restrictions, which kind of sounds like an oxymoron, Section 35 defines maintenance as maintenance, repair, and property management services that manage and maintain the safety, security, sanitation, and operation, including of residential properties, as well as commercial if you have a commercial condo. So yeah, I would say right on point there, Michelle and Patricia, and limiting, I think, the amount of people is also key because you don't want, generally you have more likely than not the board attending with the manager now maybe have a quorum of the board going or maybe just one director seeing what is necessary. Taking into consideration the restrictions. So very, very good questions. One more question for you, Michelle, before we move on. When it comes to finally opening up amenities, whether it's pool, gym, or anything like that, would you, as managers, usually use professional cleaning services, or would you want to have owners participate and volunteer in cleaning, or what do you think would be the better approach?
So, in my experience to date, we have used either our professional cleaning company or, you might have a superintendent employed full-time at your corporation. Just solely my opinion, I feel that there's a slight risk to leaving it up to residents. Now, I don't know, I think I would err on the side of going with your professional janitorial company or your superintendent and working that into your current cleaning schedule. I think obviously, like if you're reopening your gym when that's permitted, having sanitizer and wipes so people can wipe down the gym after they use it, I think is beneficial. But I don't think I would solely rely on resident volunteers to be handling proper disinfectant procedures for COVID.
Alrighty, thank you for that, Michelle. So we will now move on to the next part, which is that, as Michelle mentioned, we have a little bit of guidance now from the courts of what boards can and cannot do. If you are not aware, not too long ago, we had a very interesting case come out with respect to mandatory masks, Halton Condo Corp 77 and Mitrovic. In this case, the court ordered two owners to wear a mask or face covering while on the interior common elements, but did grant some exceptions because of medical accommodations, which they raised. But they did not have to wear masks from the elevator or from the entrance to their unit, as well as to the parking area. These owners raised the exemption of disability, but did not provide any evidence to that effect to the corporation until they got to the court. What's interesting that under the Reopening of Ontario Act, masks and face coverings are mandatory in all public and indoor settings in Ontario, which includes condominiums, both residential as well as commercial. Like many other cities or towns, Burlington also passed their own requirement. But the city of Burlington said that you can use the exemption of accommodation, but you are not required to provide any proof of that requirement to have an accommodation. So the condo passed a policy saying that we require you to provide proof of the accommodation request. And if you do not provide that proof, you have to wear a mask. The owners said, too bad. The city bylaw says you cannot ask for this kind of information, so we will not provide it to you. So mandatory mask policies, many corporations have passed them, most successfully enforce them. But now we have guidance that they can not be more stringent than any local bylaws. And like I said, in Burlington, you are not allowed to ask for that medical directive or backing, as in any other disability request. Michelle, Patricia, where does this leave us with mandatory mask policies and condominiums?
Can I just say I completely disagree with that decision, first of all, because if you actually look at the reasoning, all the good law was not substantiated in the decision. I think it should have been appealed. I commend the condo for going out that far, and I wouldn't change my advice. I think you have to have policies in place. The objective is to minimize or eliminate the spread of the virus, and good on them that they had a policy. I do think that governments should be supporting other levels of governments, including the fourth level of government, which is a condo, where we have people congregated in spaces, where we have to be thoughtful. We even have aging populations in our communities. Not everybody's going to get the vaccine at the same time. So, really, I do think that this actually shows a lack of coordination. I do think if you're looking for accommodation, human rights policies still should be adhered to. And I don't think all the other law gets thrown out of the window. I think there are other good cases that support asking the right questions to show that you need accommodation. Because here's the thing, people can always self-diagnose. I think Google is a great invention because it makes us all doctors and we can prescribe our own solutions. But that doesn't mean that that's the only solution or that's a solution for the community. We're balancing interests. So what if I actually protested that ability to say, no, you have no right to infect me? Because here's the thing, other people could be carrying it and spreading it. The mask helps stop the spread as well. So there's a balanced approach. You're actually showing your neighbor that you're thoughtful about their interests as well. And it reduces costs to the condo because the condo can actually have consistency in its enforcement and manage its cleaning of the common elements in a more productive, structured way. So I don't even understand that decision. Sorry, that's just me. And, 25 years of practice has taught me that the courts don't always get it right. So that's just my take on it.
There's a reason that you can appeal, right?
Yeah.
I've said it before and I'll say it again. I'm shocked at this decision. The fact that we can request a medical directive or something to show that the individual requires them accommodation in any other instance in a condo, whether it's a ramp or a fan or a different kind of awning or something, but in this instance where you can actually impact other people's health, we don't.
And their life, like people could die from this kind of thing. So I'm kind of questioning it because there was not even the medical evidence. I read the note that was provided by the doctor. Well, what kind of evidence was that? That's not even evidence, right? And the point is, there is scientific evidence that shows the opposite, right? So my question is, so if you go to court and you present this balanced approach to evidence, shouldn't the judge be backing up their decision with the evidence presented and assessing the case based on the merits of the evidence? Because judges are not doctors necessarily. They should have the right medical evidence in front of them to make that call, to say, yeah, you know what, there is evidence that you have breathing challenges. And if it's that evident, it should be supported by scientific objective evidence. Like, to me, I don't get it. Right? How is a doctor proving it to themselves if they're not doing the work? They're doing the work. So it is in somebody's file. And I don't think it's a breach of privacy because you could actually keep it private. You could keep the medical evidence confidential. In your information management policy, it could just be at the board level. Similar to what Michelle was talking about, but we don't tell anybody who's got COVID. We just make sure we're managing the issue in private. So see, I think that takes us backwards. I think that's a lack of, everything that the judge said as what the role of the judiciary was missed. Still don't get it.
How about you, Michelle? How are you interpreting this decision as a manager?
Yeah, so we circulated when the decision came out. We circulated kind of it amongst our leadership team because obviously this is a huge impact on our communities potentially. I think from a management perspective, I think corporations maybe felt this sense of protection in the policies they were putting in place because they were, they felt, I think, from my perspective, we have felt a protection because there was, there's the Ontario mandate, there's the Halton, there's the Burlington, and we thought, okay, we can enforce masks on the common elements. Like this is something that we totally have the ability to enforce. And then this case comes out and is like, actually, it's very easy to contest this and you don't even really have to prove much in order to be exempt. So I think from a management and a board perspective, it potentially creates a lot of challenges for us. And all these boards have done, management and boards have done over the last year is do their best to protect their community. And now this decision kind of hinders that. So almost, I don't want to use the word fear, but a little bit of fear on our part, like, oh gosh, this is something else we're going to have to deal with and potentially fight. Do we fight it with this decision that's come out? Or do we just say, okay, you say you're exempt, carry on your way? So I think it just creates more work for us. Patricia.
Well, and I also think, are we a private entity or not? Like, I mean, they keep wavering between these dynamics. And I think there was a great case, I've forgotten the name now, but out of Ottawa, which sort of reinforced the power of the board to create reasonable policies. Why are we not giving deference? Because here's the thing, aren't the boards the one doing the actual factual analysis of their community? We have 75% of seniors here, Patricia. So you know what? We think a mask policy makes the most sense. If somebody needs an exemption, let them come and talk to us, because then what we can also do is proactively manage it. So here, the courts are forcing us to get into fights, but they're not even upholding our authority as a fourth level of government. And yet they tell us we're private property. Like, which is it now?
There's a lot of inconsistency, and if it gives any solace to anyone, it doesn't. It just makes me more annoyed. Apparently, the City of Burlington bylaw, the way it was drafted, it was intended so that someone like a Greeter or a Walmart or a Fortino's didn't have to ask for your, evidence that you require the accommodation or that you don't have to wear a mask. That was the idea, that the controller of wherever you're attending to doesn't have to ask you. But the problem is that they seem to have just literally copied and pasted from a commercial context for an employee and into a private residential or even commercial setting, which doesn't really work, unfortunately. So, I mean, it doesn't give us much clarity, but I think you still have to hopefully use that common sense when you try to ask for that accommodation and you're doing it correctly. How about we talk about Bill 218? And
Sure.
where are we now with that, Patricia?
Okay, well, Bill 218, supporting Ontario's Recovery Act, it was granted royal assent November 20th, 2020. And the objective of the legislation is to provide targeted liability protection against lawsuits arising from exposure to and contraction of COVID. So, really what we're trying to do is say, okay, you got COVID, but you can't go and sue anybody. The Act applies to individuals, corporations, and the Crown. So it does apply to us. And under Section 2, sub 1 of the Act, it provides that no cause of action arises against any person as a direct or indirect result of an individual being or potentially being infected with or exposed to coronavirus on or after March 17, 2020. So there's a time frame. As a direct or indirect result of an act or omission of the person if at the relevant time, the person who's in question acted or made a good faith effort to act in accordance with public health guidance relating to coronavirus and any federal or provincial or municipal laws relating to coronavirus, and the act or omission does not constitute gross negligence. So right there, we've got the standard, right? So what it's trying to also do is avoid lawsuits against the government for inaccurate information. Because as Michelle said, like we've evolved, we've come from panic, not knowing anything, to now getting into a rhythm and stride around this. But we've also seen a lot of false starts and stops on effective measures. I would highlight the fact that numbers are not going down yet. They're still going up, right? So we're not necessarily doing everything correctly in the commercial settings, but I'm glad to hear that in the condos that I'm not hearing of major outbreaks, which is wonderful, given how many people live in condominiums. So condos are doing something right in terms of even if you're being a stickler around the policies and cleaning excessively, good on you, because you got a lot of people at home. So this legislation will cap liability. One of the challenges will always be, how do you prove where you got it? And how are we managing contact tracing, right? And were you grossly negligent? Now, I think the condo that does nothing and says, yeah, whatever, grossly negligent, because I don't think you can ignore that there is a pandemic. Some people would like to, but I don't think the science is backing that position. So the other thing is too, you also have to pay attention to public health guidance and federal, provincial, and municipal standards. The challenge will be where those conflict, right? We just had a debate about whether we're private or public or where do we fall. You have to look at yourself and just, because I'm a cautious kind of person, I look at it as a workplace, I look at us as residential, I look at us as commercial. We cover all of them. And that's the truth. We are a workplace for our managers or our cleaning staff. We have to OHSA compliance. So it's not that we can ignore this, right? It's not that we can just put one set of standards in place. We need to be smart enough to manage all the relationships on the premises and then think about this piece of legislation, which is a good thing, a bit of a buffer, less fear. But the objective is not to not get sued only. Lawyers think about that, but the objective is to avoid transmission of the virus. That is still the primary issue. So I think anybody or any condo that doesn't think that way could be setting themselves up for liability. That's just my take.
Yeah, I mean, as we all know, under the Condominium Act, the corporation is the occupier for liability reasons of the common elements. So anything that may happen on the common elements, so whether it be a pool or a gym and or whatnot, the corporation is responsible for. So like Patricia said, just sitting back and saying, people use your best efforts is likely not the best solution at this point. Michelle, I'm sure a lot of your corporations have taken on additional measures, cleaning and otherwise, to limit their liability. Would you be able to share with us also kind of documenting, like when workers come into corporations, what areas do they access? So if there is a positive case, how you can document what you did to minimize the spread, or you increase perhaps cleaning measures?
Yeah, so I guess I'll give you some information, and then I think a little bit later I'll talk about a different perspective of it. So one of the measures that was put in place is the mandatory screening for everyone coming into the building, which for some buildings is very easy. If you have 24-hour concierge, you have a front desk, a contractor comes through the front door, concierge is there, obviously probably behind a nice wall of plexiglass, and you sign in and you answer the screening questions right then and there. In the Golden Horseshoe area, a lot of our demographic is mid-rise condominiums. We don't have the large high-rises that you see in the Toronto area with the concierge services, and a lot of townhouse communities. So I'm going to kind of talk from the perspective of the buildings, because I think that's where this really applies. So determining how to conduct this screening, I have actually a lot of some really great janitorial companies that use like a QR code. So you take your cell phone and you scan it, and it actually opens up a questionnaire to fill out. So I think some way, whether it's a logbook at the front door, whether as the manager or whoever's scheduling the maintenance provides a questionnaire to the contractor before they come in. And then I think you have to be very clear on what it is they're doing. So I think if it's common area maintenance, usually you should have cleaning already in place, so that if your contractor went in and went up to the boiler room, your cleaners are likely already doing common area cleaning on a daily basis. So that should protect you. So I think the big thing is contact tracing. So knowing who is going into your building and ensuring that you're following the screening protocols, which I know is a bit of a challenge for some of our communities because they don't have that on-site staff in place. So I think the manager, the board, and then maybe some of their contractors like their janitorial or security need to work together to put a procedure in place that works for your community. So that's what I've done with some of mine, is if you don't have on-site staff, someone to screen when they come in, is maybe the manager's doing that before they dispatch the contractor to the property, so that they know who's there, who's coming and going.
Yeah, I think the key is obviously you want to avoid the chances of having a positive case in your condominium, but chances are you will have one. So it's putting the corporation in the best position and showing that you took best efforts and those most reasonable steps to minimize it, and then control it as much as you can once you've discovered it. A key part of this is communication. As always, I think in most condos, in any issue, whether it's that you're getting a loan or whether you're doing any project, communication is key when it comes to condos, especially when it comes to COVID-19. Patricia, would you mind going over some of the key communication tips you have with respect to COVID-19?
Sure, not a problem. I think going back to Michelle's point, we need to provide everybody with a refresher, but also a refresher on where we are today. And if we're not doing things differently, let people know that. Let them know that the protocols are still in place. And I think that the board should be actively acknowledging that they are looking at policies on a regular basis. This is something that we recommend to our boards, that, COVID restrictions are looked at, let's say, on a quarterly basis by the board to see if they're still applicable, how they mesh with all the levels of government's advice and where we are, which wave we're in, and what the restrictions are. So a consciousness by the board, updating people is helpful. The other thing is too, what we've heard in the news, I've heard it quite a bit, is that some people are having trouble accessing the vaccine distribution systems that are available to them. So why not try and share information? Rachel, if you're able to share on your screen just that listing that I sent you, that would be great. Thank you. So what we've done is we've put together a listing for Golden Horseshoe of all the various areas that you can access or have your community members access vaccines. We're going to make this available. We're not going to spend a lot of time on this now, but getting this information out in a condensed form with links is one part of the communication strategy, because now we're seeing stratification on different methods, including public facilities like pharmacies, etc. So that is going to help the inoculation program roll out effectively, especially if we have the vaccines in place. But the other thing is to maybe asking for volunteers to help those people who are having problems booking online. That might be something that can be done remotely with the help of those tech savvy people in your community. And like I said, reminders that policies are still in force. And then what the plan is. Like I also think we also need to give people hope and where we're going. And you don't have to promise anything in terms of opening amenities, but you have to promise, like, we will look at it as soon as we're able to do that, so that the board is really being conscious and in communication, contact with your community.
Excellent points. And you touched on one that, let's go into it a little bit deeper, policies. So 5 days ago, the CAT released a decision more on a corporation's right to create policies. Durdan and PL Standard Condo Corp 843, hot off the press. In this case, the condo established policies with respect to visitor parking. So nothing COVID related, I know, shocker, right? But it is relevant to this context. The policies dealt with who could use the parking spaces and on what, for how long, so 8 times per month. And it also authorized ticketing. The corporation's declaration and rules did not have any of these provisions within them. So they were all within the policy. The owner was using visitor parking, and the corporation wanted to enforce its policies with respect to that. So it went to the CAT, and the CAT ultimately decided that the provisions in the policy should have been made by way of a rule, which requires notice to owners, the right for owners to requisition a meeting and to vote against it, failure of which will mean the rule is enforced 30 days after that or on the date the board decides. So where are we now? Back in September 2020, we actually reviewed another case during our other COVID talk, and it was Fraser and Toronto 1704. And in that case, the court said that the board of directors has a right to establish policies. And that policy in that case dealt with renovations and prohibiting renovations at the time of the pandemic or lockdowns. So we had a great case that said we can have policies, we can enforce policies, and the court said in the same manner as rules. Now, fast forward to 4 days ago, the CAT says that some provisions have to be in the rules and not policies. So where are we today? Can we have policies? Are they enforceable? Do certain provisions have to be contained in the rules? Are policies supplementary? Are they procedural only? What do you guys think? It's a big one, right?
Well, but I think that you still have to go back to the framework of the Act and appreciate, where rules are supposed to be, approved by the majority, or at least the opportunity to protest the same is given, right? Like, because I think that's really what it is that there are certain topics that are not going to be clearly in policy. They go beyond operational, but I think the other piece here with the COVID dynamic is Section 117 really focuses on the corporation's obligation to not have a dangerous condition exist that can cause harm to person or property. And I think that's where the balance is, right? The board has to make that conscious thought decision as to what will be those parameters in terms of operationally keeping the community safe. I don't know if that's something that should be voted on versus rules on parking. Parking, I see. People may have different perspectives. We can have Zoom meetings. We're allowed to have Zoom meetings now till December 31st without the bylaws in place. That is more a forum of discussion. And I think that's where guidance by legal counsel may be helpful, is when are we crossing the line? I think, the CAT's decision is helpful in bumping us up against, a boundary or a line to say, okay, maybe we've overstepped here. We should redirect. But I think Fraser is still good law because I do think 117 weighs heavily in this pandemic on the shoulders of boards. Michelle, what do you think?
Yeah, I think policies, in my perspective, typically I think they're used supplementary to the rules. So the rules might have, let's talk about renovation. I know that's what's the Fraser case. So the renovations are subject to board approval, very basic rule. And then your renovation agreement or policy really stipulates what subject to board approval is, really outlines what those requirements are. So I think most often when I see policies used, they're used to further elaborate on a provision in the rules. I think what I see boards sometimes doing is where they might get themselves in a little bit of trouble, if ever challenged, is they have a policy. This is the policy. You can't park more than 8 times per month in the visitor parking. An owner challenges it and says, okay, I want to see said policy. Oh, well, we've never written the policy. It's just the way we've done things the last few years. So I think one way to really, maybe protect yourself as a corporation is write out the policy and circulate with your owners so they're all very much aware of what the policy is. Because I do stumble upon that more often, I think, than I'd like to, is that, well, it's just the way we do things. Okay, well, is it written? Is it communicated to the owner? So I think that's a way to protect yourself, is to make sure that you're formally documenting these policies and circulate them to your owners so they're all aware of what the policy is. But I think it's important to allow some things to be in the form of policy and not the rule. Like, let's talk about COVID. Imagine doing a rule update for all the different ways COVID has changed over the last year. So I think policies are beneficial because they're fluid. You don't have all those hurdles to go through to get it approved by the owners. You can put it in place and do what it needs to do. So I think they're great, and I think they have an excellent use in condos. But I think the key thing with boards is really make sure you're documenting them and circulating it to the owners when it is created, or have it as a extension, appendix A of your rules. Okay, here's the rules and here's the policies that support those rules. So I think that's how condos should approach it.
I agree with that. I mean, the court in Fraser back in September of 2020 said that the policies, like Michelle said, are fluid. So what may be relevant today may not be relevant in even a month or even next week. So that's, I think, that a big difference between rules and policies to some extent is that you have to be a bit more proactive in the sense of this has to be done today. And it does show more of a procedural application than you can or can't do this. We just had a poll going. Oh, go ahead, Pat. Patricia?
Yeah, I was also thinking that, if you look at them, they should all work together in tandem. I think policies are corporate governance framework for a condominium corporation to allow for smooth operation. Rules should be complementary to that, but often policies also speak to a higher set of responsibility at the statutory level, even for human rights management or privacy management, where there are, bridges that need, or areas that need to be bridged because there are gaps in how they directly correlate. So well-written policies should really never antagonize the concepts under the statute, which give us, latitude to create rules, but they should work together. Like, it should be deductive the way I see it, because you're trying to marry all your legislative responsibilities together.
Which there are enough to keep track of.
True.
Without COVID.
Without COVID.
So one question that has come up a couple times, not only before the seminar, but during the seminar or this webinar is, what about vaccination passports? Do you think you're going to be able to require an owner to show proof of vaccination to use a pool, or visitors to attend a condo to show their passport before they go see an individual in the condo? Is this even a viable option?
I'm happy to jump in on this because I think I love this I love that we're talking about this subject personally, because I work with boards. I've worked with boards for many years, and when we were planning this session, I brought this up because I know in a few months, one of our managers or myself is going to be sitting at a board meeting, and a board member is going to say, "Okay, well, we'll open up the amenities, but we want proof of vaccination from everyone." So I think it's an important conversation to have because we know that this conversation is being had elsewhere. You know, I think one of the NFL teams said, if you want to come to the stadium to watch a game, you know, you need proof of vaccination. There's been rumors about Ticketmaster to go see a concert or flying even. So it's happening in, you know, the public sector with other organizations. So I think it's an important conversation for us to have. And I'm interested on the legal perspective on how you think, is this even a possible solution? Would you recommend a corporation even try it in place?
Well, Maria, do you want to jump in first?
Sure. I'll put it to you this way. I will not be the lawyer that will be giving you an opinion that you can legally enforce a vaccination passport. I do not see that ever becoming a possibility, especially if we don't have the direction from the government. So unless the federal provincial government comes down and says you have to be vaccinated or else, I don't see it being a possibility. Now you can ask and they can say no. So nothing stops you from doing that. But I don't think, no, you cannot require a vaccination, at least not at this time.
Yeah, I would agree with that. I think privacy is still something we value. And I think, you know, as a society, we should still not lose sight of our values as an overall part of our vision. But I also think that the other fundamental piece is our objective is to stop the spread. So you could be inoculated, but you could still be spreading. So this is the bigger issue. Even I think we should look at the problem in a different perspective, which is, okay, so more people are getting vaccinated, but not 100% of the population has had access to the vaccine. So what that means is everybody still has to be cautious. We cannot let our guard down. And if you are carrying the COVID variant and you've got a boosted immunity because you got your inoculation, that's great for you. But that doesn't manage the risk for the person that's going to use the treadmill right after you. Condo still has to be cognizant of what it's trying to manage. And until there is, you know, mass inoculation, you don't see the numbers go down. And I think that's the other piece we need to really think about. So which part of this risk are we managing? And what is it going to gain in terms of my knowledge as a condo board member that you've been inoculated? It hasn't helped me manage the risk more. So I think the question is also, why do you need the information, right? Because are you looking for a benchmark in your community to say, we're at 97% inoculation, we're good to go? That's interesting, but I don't know if these variants really care if you're inoculated, as far as I've heard that. So I think it's also where the science is, what we're relying on, and what risks we're managing, and does it make any sense? And do we value privacy? I think we do. Like, even if somebody has COVID, we're still putting a wall around those people, not identifying them, but trying to help them, right? That's where the kindness, compassion, and protecting the community comes back together. So I don't think the passport is a good idea. As much as passports may be popular once upon a time, I don't think this is the type we're going for.
Yeah, I mean, we just had like a 5-10 minute conversation about masks and someone not required to provide any documentation that they're exempt. And now we're going to say, give me your medical history. Yeah, I don't know how you reconcile those two positions.
Right. And for what purpose, right? Because I still think that we have information management policies that we recommend to clients. We still have Section 55 of the Act, which is, you know, you have to really be thoughtful about what information you've got, how you're going to use it, how you're going to disclose it, why you're collecting it. So you'd have to update your policies. I think everybody, if you were going to ask those questions, you'd have to have very tight restrictions around that.
Yeah, absolutely. It's kind of like, you know, if you have video surveillance at your corporation, you should have that surveillance policy that says what is its use, who has access to it, who does not have access to it, why do you have access to it. And this is now we're talking about medical information, so it's a little bit even, you know, higher there. Michelle, can you talk a little bit about essential construction during this wave of COVID?
Yeah, definitely. I think this is very timely because anybody who's lived or worked in a condo for a period of time knows spring is where it's at. Spring walkarounds, spring maintenance, landscaping. You know, it's very busy, typically a very busy time of year for us. And last year we missed out on a lot. You know, a lot of condos deferred because we were in that panic, unknown territory state. So I think we can definitely go with a different approach this year, knowing what we know now. And Rachel, our moderator, has a great poll up, just kind of gauge, what do you think classifies essential construction or maintenance at this time? The government has given us some guidance on this, as Maria talked about at the beginning. I know there was some concern for people who had large projects in play. And I think we've learned from the prior shutdowns that we've gone to, and this one gave guidance as well, that if it was in progress before the order came in, there's a cutoff date. So for this one, if it started before April 17th, 2021, you're allowed to continue. So if you have a major project going on, it does not mean that you automatically need to close, end that right now. What I think we need to have a conversation about is looking at operational maintenance and construction versus capital projects, capital asset maintenance and construction, and how we approach each of those. So operational side, we're talking window cleaning, garage cleaning, usually it's semi-annual HVAC inspection if you're in a high rise, or your annual fire inspection. I think when we talk about whether or not to proceed with these types of projects, I think you have to look at the logistics of it. So just looking at the poll, everybody indicates that HVAC cleaning, 83% of you feel that that's essential. And I would agree at that. We all, you may or may not know, but HVAC cleaning or the HVAC maintenance is really important to the overall function of the equipment. And in high rises, although you may have a fan coil or a heat pump in your designated unit, they all feed together in one loop that runs off of the major equipment up in the boiler room or the mechanical room of the building. But I think, so it's classified as essential. We're allowed to proceed with it, but you still have to take the steps to manage risk, as Patricia has talked about quite a bit. So don't forget the procedures and policies you need in place, proper PPE, limiting contact. One of the ones that I when we were talking about this, I kind of wavered on was garage cleaning. So I think where people hesitate on the garage cleaning is that you have kind of a mass descent on the garage for everybody to move their cars. And depending on the size of your parking garage, that could be a lot of people, down there trying to move their cars before 8 a.m. of the day of the cleaning. So I think if you communicate and plan the logistics of that, it can work. I think you can proceed with these maintenance items on the operational side. When we talk about, capital projects, capital assets, I think this you have to, if it wasn't already in progress, I think you have to give a little more insight into this. So one of the comparisons we wanted to talk about was corridor refurbishment project versus sealant replacement project. Sealant replacement project, you're typically on a bosun chair or swing stage on the exterior of the building. The contractors likely have to go through the common areas minimal times per day. Once they get all their equipment up on the roof, they kind of just go in, hop on the roof, and descend down the exterior of your property. Very limited exposure to your residents. They're on the outside. They don't need to, be interacting with people. So I think that's one project that you could consider proceeding with right now. Let's talk about corridor refurbishment project. It's cosmetic. Likely you're not doing corridor refurbishment project to deal with water leaks or anything along those lines. So I think the fact that it's not It's more of a cosmetic as opposed to repairing building exterior. That gives you a little bit of guidance. But I think also if you're doing a corridor refurbishment project, you're going to have contractors in your hallways, your lobbies, all the common areas that residents use as their main traffic in and out of the building. So that's something I would caution myself and my boards against proceeding with, because the logistics of it really just don't work in a pandemic setting. So I think we can certainly proceed with construction and maintenance and repair, and the government has given us guidance to do so. But as a board and as a manager, you need to look at the project that you want to tackle or the maintenance that you want to tackle and determine if it's absolutely necessary and whether or not you can conduct it safely without, creating any additional risk to your community. So that would be my tips for kind of tackling construction and maintenance moving forward. Really, really look at each project.
Yeah, and I think, sorry, I just think assessing the risk, right? Like having your boards, really be cognizant of that. Everything that you just analyzed, you were looking at the risk of transmission in that, and then how to set it up, right? So it's the underlying pieces of policy as well, which is what are the COVID requirements for the condo, even if you're a supplier that's allowed to come in. It's not just about approving the project, it's the secondary layer, and how is that going to be managed as well. Sorry, Maria, I interrupted you. Go ahead.
Oh, no problem. I was just going to have a question here. So it was someone submitted this before the webinar. With respect to high-rise condos, I guess some are experiencing higher financial obligations now because of cleaning and perhaps other issues. How are you as a manager assisting corporations in dealing with this, going over budget for things like maintenance or superintendent, perhaps, things like that? Do you have any tips?
Yeah, so first I want to kind of make a very quick comment that I'm sure a lot of people have encountered the question from owners, well, I can't use the clubhouse or I can't use the amenities. Why aren't I being refunded? Prime exhibit A right here, because while you may not be using those facilities, you may get the impression that you could save money on that, which you might, right? If you're not cleaning the gym because it's not open, you are going to save a little bit. But that cleaning that's not being done in the gym has now been increased in your other areas. So I think that's a great communication piece to use with your owners if you're being pressured, and the lights are still on and the HVAC's still running. So I think reviewing your financials as a group, when I say group, board, and management on a monthly basis, keeping an eye on those expenses. You might need to, if you're really running a financial deficit or your financials are in a poor shape, you may need to, what I would talk to my board about is, there's kind of two options. We could either, if you're close to your year end, we could recover it in the next fiscal year budget. If it's a really bad situation, you may obviously need to look into a special assessment of your owners, which I know nobody likes, but that might be an option for you. The other option I think you could look into is, playing with your financials a bit. Did you have a project planned? Maybe you had some grand plans for landscaping this year that unfortunately just can't be done now because you have to reallocate those funds to covering the deficit for increased COVID costs. So I think look at your financials, look at your budget, look at your planned expenditures and see if you can move things around a little bit or cut out some other costs or projects that maybe aren't absolutely necessary to cover that deficit. But I think reviewing on a monthly basis your financial statements and having that conversation with your board and manager to assess what your options are.
Thank you for that, Michelle. So we're going to have one more question. We received lots, so thank you so much for that. One last question before we end, though. So we have someone, anti-maskers and anti-vaxxers. Not everyone supports vaccinations. Not everyone supports masks. People that go about the community, though, and are very vocal about it, perhaps maybe a little bit disrespectful. How do we deal with these kinds of, or these types of individuals? Do they have a right to impose their opinions on others? How do you manage the situation? Perhaps posting things in the elevator or on the condo website.
Yeah, I think just a quick property management perspective on that, and then I think I want to flip it to legal for a little bit more guidance. But I think typically buildings have policies governing. I know I've worked with buildings that have websites and they have policies that how you are to conduct yourself on the corporation's discussion forum. So having that in place, and perhaps you can use that to say, you know, your posts do not meet our community guidelines. And then a lot of communities and buildings have, you know, you can't just post things in the common areas. They even have parameters, you know, you need to get manager approval before you can post something on a bulletin board. So perhaps you have policies within your community where you could say, you know, the behavior in which you are proceeding with does not meet our community policies or guidelines. So Patricia, I don't know if you have kind of more of a legal perspective on how to handle this situation.
Well, I think it's about, there has to be a balanced approach. I think when we don't have all the voices at the table, I think there's also a problem there. But I think it's about what exceeds what's reasonable based on just usual guidelines in terms of content. But there are going to be a variety of positions on this issue alone. I mean, COVID highlights that. But are we going to stop the dialogue? Probably not. Is it better to have some level of accessibility to the community to share? Probably. But you know, it's managing those forums and what kind of dialogues we end up getting into, because people will have different viewpoints. But at the same time, there's a board that's elected that provides the compliance with the statutory obligations. So Section 117, together with all the case law in Ontario across the country, that actually provides judicial confirmation that there is a pandemic, is the standard from which the board will operate. There is no other judicial finding to support the other views. The evidence is very clear in the case law. And the most recent case that we talked about today actually talks about the cases that confirm the existence of the pandemic. So looking at it from an objective corporate perspective, corporations are expected to comply with the laws of the province of Ontario, which include case law. So it's not about adopting something that would be contrary to the findings of the court, right? So it's finding that balance. Forum is okay, but leadership complies with applicable laws. That's my take on it.
And we know that the court in Fraser did confirm that COVID is real. It does exist. And of course, communication always has to be and should be constructive and respectful. But if it gets to the point of being harassing, that's when you want to start thinking of enforcing any rules you have to that effect with those individuals. We are out of time, and I have no idea how an hour passes, but I do at the same time because it's Michelle and Patricia, and they're just fantastic. Thank you to you both for sharing your experiences and thoughts on this matter. And thank you to everyone who has joined us at today's webinar. Our upcoming courses are, we have dealing with harassment. Okay, we did not plan this, but that is very timely because we finished exactly on that point. So dealing with harassment on Tuesday, May 18th, that is our next Condo Talk. Then we have the CCI National Conference, which is not technically a Golden Horseshoe chapter event, but we do certainly encourage you to attend since it is all virtual, very easy to attend. The keynote speaker will be addressing how AI, artificial intelligence, can help condo boards work more efficiently. Other sessions are Ask the Expert, a pure, so Q&A session, and a legal panel covering recent rulings all across Canada, including Ontario. So please register on the website at cci.ca. We also have the Intro to Condos on June 17th for anyone who is new to the industry or who would like to have a refresher. But again, thank you again for attending today. We welcome your feedback as always. Please send in your questions. We do review them before every Condo Talk and try to incorporate them and answer them as best as we can. And we hope you enjoyed today's Condo Talk and look forward to seeing you again soon. Have a great day.
Thank you.
Thanks.